Welcome to today's program titled Artificial Intelligence in Employment: What New York City's Local Law 144 Means for Automated Employment Decision Tools. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP, for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Annette Timon. Annette, please go ahead.
Great, thank you so much, and thank you to everyone who is here participating on this webinar. We really appreciate your time. We know that the requirements in New York City and AI issues in general are top of mind for many employers, so thank you and welcome. For those who don't know me, my name is Annette Timon. I chair the People Analytics Group here at Seyfarth Shaw. And we have a terrific group of speakers today that have joined us who have really unique expertise on these issues. And the first person I'd like to introduce is Rachel C. We are absolutely thrilled to announce that Rachel has joined us recently, and she is going to be our Vice Chair for Emerging Technology and People Analytics. And she really does bring some real expertise to this space. She has spent her career at the intersection of law, technology, and policy, and will be now providing Seyfarth with many of the tools and insights that they need to help employers as they navigate various AI issues. She comes from a regulatory background as well on compliance issues, and she's not limited to employment, which makes it fantastic, but she also has policy and enforcement expertise. She also has a really unique technology perspective, and so she's going to be assisting us moving forward, and we're thrilled to have her. We're also joined today by Rob Ziba, and Rob is a partner in our New York office, and so he has spent a lot of time thinking about the issues that we're going to be talking about today. He has testified before the New York City Council and some of the sessions that they had, provided testimony. We've worked very, very closely, and he really is a thought leader in this space. And we are also lucky to be joined by Joe Avelli, who is an associate in our People Analytics practice group, who also has spent a significant amount of time thinking about evaluating issues related to AI, as well as a host of other issues that we deal with on the People Analytics team. So with that, we'll turn it to give you some insight into our agenda and where we're headed today. First, we want to just set a background and provide some legislative history around the New York City law. We're also going to be talking about what constitutes an automated employment decision tool, which is critically important under this new requirement. We'll spend some time talking about the jurisdictional scope and how far the reach is, or how narrow, as the case may be, what's required for a bias audit and who's an appropriate auditor, We'll touch on notice and disclosure requirements, which are going to be top of mind very, very soon here, as well as talk about the interplay between what's happening in New York City in particular, and various anti-discrimination laws, and then what we're seeing on the federal and landscape, as well as EEOC assistance that they have provided, technical assistance that they've provided. So with that, I am going to turn it over to Rachel, who's going to kick us off on a few, high-level, broad thinking on artificial intelligence issues.
Thanks, Annette. So on the next slide, you'll see the assertion that AI is already here and changing the world. When I started talking about AI, when I was giving these AI presentations last year, at the start of last year, that would give some people a bit of pause. It's like, well, what do you mean AI is already here? I'm not seeing robots walking around. I'm not seeing things like in the movies, and we don't have to dwell too much on this. That I think some of the breathless talk about AI from the movies and some of the risks that we are hearing, they're things that we should be talking about, but not here. That the risks that some of these regulations, like Local Law 144, are intended to address are risks from very specific applications. And we're not talking about AI in the movies that understands like a human being or understands concepts like discrimination or emotions or any of these other things that are very high level. There are ways that some of the technology looks like it does or has the facsimile of it, but there's really some very narrow applications that, including in the labor and employment space, that have significant risk and significant benefit if used correctly. So the context of AI, we call these tools, some people are calling these tools automated employment decision-making tools. And on the next slide, you'll see some of the applications in the HR space, in the employment space, where these tools are already being used. And so as you look through this list, from sourcing and recruitment to onboarding and retention, all of the routine nuts and bolts of HR, we have algorithms, machine learning, deep learning, artificial intelligence, all this technology, this new technology being applied to these HR functions. And regulators, including the New York City Council, looking at this and expressing concern that there are ways that these tools could have a discriminatory impact. So with that, I'll turn it over to Joe, who's going to talk a little bit about the history, more of the history of Local Law 144.
Thank you, Rachel. So on the next slide, we provide you with a little bit of a chart of the progression from the passage of Local Law 144 by the City Council, Mayor de Blasio not signing the measure and it automatically going into effect in December 11, 2021, and then the law becoming effective of January that following year. Between now and the July 5th effective enforcement date, a lot of action took place, right? We had several rounds of proposed regulations coming out. We've had the final regs come out last month, and also a roundtable was held by the city, by DCWP, to further elaborate on what this law actually requires employers to consider and the general scope of this law. And so a lot of moving parts, a lot of information to dissect between, when this law first came out and now this few weeks before enforcement is supposed to begin. We really want to be able to dissect this information a little bit further, provide an update on where we currently stand and what we understand the requirements to be as we await these FAQ type guidance that DCWP said will be released, hopefully not the day enforcement begins. So on the next slide, the basis of this law, if we move on to the next slide, is that New York City employers are prohibited from using tools that substantially assist or replace discretionary decision-making unless, as we all know, a bias audit takes place within 1 year before the use of that tool and notice is provided to employees and candidates. At a minimum, there are certain requirements these bias audits must take on when we're running those analyses in order to be compliant with the law. And so there's two big takeaways. It's the bias audit, what's going into it, which we're going to cover further on in this presentation, and the type of notice that needs to be provided to your job candidates, your employees that are up for promotion, when an AEDT will be utilized in that selection process. With that, I'm going to kick it to Annette to really break down what an automated employment decision tool is.
Okay, great. So let's kick in and kind of get into the nuts and bolts of what's really covered. As Rachel, set up for us, many employers are already using some sort of algorithmic tool, some sort of AI tool, some sort of machine learning in various aspects of the employment process, okay? So when we're looking at New York City, it's very, very important to really unpack the definition, to really understand whether the tools that you are using within your organization are actually covered or if they're not. So, as we'll talk about later, whether it's covered in New York City, it may be narrower or a narrower interpretation as opposed to the broad issues. But what you'll see on the screen right now is the definition as set forth in the law. What we decided to do for purpose of this presentation was, at this point, as Joe mentioned, enforcement begins July 5th. So we assume at this point that you already have looked at the definitions and have studied them and thought them through. The regulations that came out, the final regulations that came out, really provided more context to this. So what we have in front of you, every area that's highlighted, so machine learning, statistical modeling, data analytics, or artificial intelligence, is also defined in the regulations. So as we think about this, one thing we really encourage you to do is take a very close read at the text of the law as well as the definitions in the regulations and bring them all together to really assess whether or not you have an automated employment decision tool under the framework that New York City is providing. So in the next slide, what we started to do was kick off some of that for you, and we process mapped this. I know there's a lot of information on the next 3 slides. We're going to break it down for you, and the good news is, right, we're sharing this deck with you, and these process maps will be in there. Because 2 points I want to make first before we deal with the specific questions is, keep in mind that part of the definition refers to an employment decision that's made. An employment decision is defined in the materials that have been shared by under Local Law 144. It is to screen candidates for employment or to assess employees for promotion within the city. So based on that, we are talking about hiring and promotion decisions, and that definition of candidates for employment is also defined as an individual who has actually applied for a position or promotion within the organization. So one of the things that Rachel talked about was sourcing, right? So we know that tools are being used in the sourcing context. Whether or not they are actually going to be covered, such tools would be covered under the law, is going to matter very closely about how all of that work is done and generated in the specific tool that you're using. But you just, you should have really take a really close deep dive into the issue. So there's 3 major questions. First, is the tool a computational process that is derived from machine learning, statistical modeling, data analytics, or artificial intelligence? So one of the first things you're going to ask is the tool using a computerized technique to prepare calculations or, confirm some or perform steps? If that's the case, then you move on to the next issue. Does the tool itself, right, did it make any type of prediction? Does it make any type of prediction or assessment about an individual or their candidacy for moving on? Or are you going to, keep them? You're going to decline them, or you're going to move them or categorize them? If that's a yes, then you move forward in the analysis. Or does the tool classify? If that's a no, does the tool classify or categorize individuals, right? So if you're ranking folks, if the tool is ranking folks, you're gonna move them forward. So all of these decision points are really, really important to unpack. Did the computer, rather than a human, decide the factors that are evaluating an individual? That's a critical component to this analysis. If it didn't do that, right, then another question is, did the computer, rather than a human, determine the relative ranks or importance of the factors that you're using, right? So to the extent it's computer generated, there was some sort of machine learning or algorithm that said, based on all this data, for example, here are the top 3 things that we want to determine high performer or to determine leadership qualities, something along those lines, right? If the machine is doing that, an algorithm is doing that, then you're going to, more likely fall with regard to this particular question in the yes category, assuming that all the others have also been answered in the affirmative. And if not, then, right, you're at a different point. So you take that question and we go on to the next slide. The second question deals with, does the tool issue a simplified output, including a score, classification, or a recommendation? And when you assess all the definitions that are in the text of the law as well as the regulations, it's going to give you some, some framework here regarding, does the tool rate or score candidates at any stage in the process. So it doesn't have to be the final hiring decision or the final promotion decision, but at any step in the process. Or is it tagging folks, or is it, categorizing, green, red, yellow, like anything along those lines would be a part of the simplified output. And prioritizing one employee or candidate over another. Then on step 2, if that's also a yes, then you'll get to step 3, which is the final piece of the puzzle that you're working through to assess whether that overall tool is going to fall under the definition of the New York City automated employment decision tool. So question 3 is the tool being used to substantially assist or replace discretionary decision making, right? So if the tool, for example, is solely determining the outcome, right? So after all the yeses and nos that we've talked about, now you get this score, this classification, or this rank, and that particular a decision point is determining yes or no on a candidate or moving someone forward, then that's going to fall under, it'll be the third component. If not, does that tool or that assessment outrank any other, right? It's given the most weight what the machine is saying. That's also going to put you in the yes category. However, if at some point in the process you've got humans coming back and looking at the decision and overruling it, or conversely, if the tool itself is overruling human decision making, then that is going to be considered a tool that is used to substantially assist or replace discretionary decision making. So you'll have the information here in the process map, but we tried to break this down a little bit for you all and hopefully give you better context around what's included and what's not included, because once you make that decision, then there's a lot of additional work. And so getting this question right is really important from a next step perspective. So with that, we're going to turn it over to Rob, who's going to kick us into the jurisdictional scope and coverage issues.
Terrific. Thanks so much, Annette. One of the things that's, in addition to the analysis of what an AEDT is, which is incredibly important for figuring out what your legal obligations are or what requirements are under New York Local Law 144, another component to this is jurisdiction. Who's covered, who's not covered, what are the circumstances, and what's the analysis that we need to conduct to figure out whether or not we fit into the jurisdictional scope of Local Law 144. As you'll see on the next slide, there is a couple of guideposts that we can go by. So the cornerstone of the analysis really is going to be that the location of the position is the first step in the process. When we talk about local law 144's requirements, we see a lot of references to requirements applying in the city. In the city, when the Department of Worker and Consumer Protection explains it, really refers to the location of the position and where that position is located. So, a couple of easy softballs to start with. The position is located in New York City itself. So we have a worker who's working on site, the location's in New York City, bias audit is required, notice is required to residents of New York City that are applying for that position. Relatively cut and dry analysis. Equally cut and dry seemingly is when a position is located outside of New York City. So physical boots on the ground, brick and mortar position located outside of New York City, a bias audit and notice under local law 144 would not be required. It's not going to be that easy, unfortunately. And in 2023, the reality of the workplace has really changed dramatically from just those two dichotomies of having brick and mortar workers on site. With fully remote positions and virtual participation from employees and hybrid positions, the analysis really has become a lot more complex. Not just that dynamic, but as we have workforces and employers and companies that have location, have multiple locations and multiple jurisdictions, that analysis further gets complicated. So we can start off with a couple of guideposts that we've gleaned from the Department of Consumer Protection's guidance that we've received so far. When an employer has an office in New York City and is advertising for a position that is going to be fully remote, the bias audit and notice of local law 144 will be required. So this contemplates an employer that has probably one location or a few locations, all of which are going to be in New York City. And even though that employee is going to be remote, they'll be reporting in and effectively working outside of the New York City office, even though they may be sitting outside of New York City and dialing in remotely. In a situation where an employer does not have a New York City office at all, if that position is remote, the bias audit and notice requirement will not apply to any AEDT that is being used. This similarly contemplates an employer that may have many locations, but if they do not have boots on the ground and they're not considered to be operating in New York City otherwise, the bias audit would not be required. To complicate matters further, when we have employers who have offices in New York City and outside New York City, and I think that probably captures a significant population of employers, especially bigger employers who have locations inside and outside New York City, for a remote position, that is going to turn into a fact-specific analysis. And as we've seen these different types of work arrangements and work relationships and different ways that this is structured, that can be a very complex analysis, because taking in the various factors that kind of comprise that role will dictate one way or the other whether or not the position or the job in the AEDT should be analyzed under local law 144. So, for example, if an employee is remote, employer has offices inside and outside New York City, certain facts that may be relevant to the analysis, maybe where is the employee reporting to? Does the employee work on a team that otherwise is located in New York City or outside New York City, or both? Does the employer's core function of what that employee is involved in, for example, if you have an employee who's in the marketing department versus the HR department versus an operational department, if the core function of that company's department that the employee is a part of is inside of New York City or outside of New York City, or both, may factor into the analysis. Does the employee come in for meetings? As you can see, these types of factors are extremely fact specific. And as we see the world evolving, the workplace evolving, this has become a very complex area that really requires a very, very fine-tooth comb analysis to really make that determination of whether or not the position is, quote unquote, in the city, and thus whether local law 144 applies. So with that, I'm going to pass this back to Joe to tell us about a little bit what bias audits require. Joe?
Thanks, Rob. All right. So as I had mentioned, one of the hallmarks of this law is that a bias audit needs to be conducted. And on the next couple of slides, we're going to go through each element of what that bias audit looks like, the type of data that you can utilize, in a bias audit, in what situations can you use certain types of data, and then some takeaways that the final regulations provide employers as to deciding what data they will be using to conduct their bias audit and publish their results. So on the next slide, we just start off very easy. What is a bias audit under the law? They didn't provide a lot of, intense definition, but it was an impartial evaluation by an independent auditor. And then later in the regulations, they came out and said what an independent auditor qualifies as. And as you see here, it's a person or group capable of exercising objective and impartial judgment on all issues within the scope of the audit. So what we do now know is what classifies someone, would take them out of the independent auditor context. And that's what we provide here in these sub-bullets. So you're not an independent auditor if you're involved in using, developing, or distributing an AEDT, have an employment relationship with an employer or employment agency that seeks to use or continue to use the AEDT, or with a vendor that developed or distributes the AEDT. And then interestingly, the last bullet, you're not considered independent where you have a direct financial interest or a material indirect financial interest in either the employer or employment agency utilizing the AEDT or the vendor that developed such. And we think that the agents or the DCWP purposely kept this provision broad. And what a material indirect financial interest qualifies as, your guess is as good as mine because they don't define it. And so we're hoping for further clarification in the FAQs, but it doesn't leave you much time to conduct your bias audits if you think you fall into one of those scenarios. The direct financial interest is the most obvious, but the important thing here is conduct the bias audits prior to July 5th so that you in good faith could say you have complied with that requirement of the law. On our next slide, we dive a little bit deeper and discuss at a minimum what must a bias audit include. And so as we have said time and time again, what we're looking for here, what has to be included in this audit is a calculation of selection or scoring rates of an AEDT to determine the impact ratio, essentially for the race, ethnic, and gender demographics collected on the EEO-1 report. So we will run analyses by sex category, race, ethnicity categories, and also the intersectionality in between both. So not only will we look at sex and race, but we will look at, for instance, how did Black females score? How did white females score? How did Hispanic females score on a particular AEDT, and use that in our impact ratio analysis. We will do the same for males by each sub-race ethnic group. The calculations really have to be performed every time the tool classifies or categorizes an employee or a job candidate, candidate for employment. An interesting development, though, that came out of the final regs was that a race, ethnicity, or sex category that represents less than 2% of the data being used can be excluded from the impact ratio calculations. However, if excluded, there has to be a justification statement as to why this group was excluded, and also explain the number of applicants and the scoring selection rate of that excluded category. So just to keep that in mind, where you have a race, ethnic, or sex group not making up 2% of that overall population. After the bias audit is conducted, we have additional disclosures that we have to be aware about. And so you see here in items 1 through 6, what has to be included in that disclosure is the source and explanation of the data utilized to conduct the bias audit, the date of the last bias audit, the number of applicants or candidates captured in the audit, selection and scoring rates for them, the impact ratio by race, ethnicity, and sex, and those intersectional categories that I mentioned, and then also the number of individuals with unknown race, ethnicity, and sex that were assessed by the tool. The department gives us an example of what that statement will look like pertaining to item 6, and they say that an example would be the AEDT was used to assess 250 individuals with an unknown race, sex, race, ethnicity category. Data on those individuals was not included in the calculations above. So it could be pretty straightforward. The important thing is that the statement is made in your public disclosure. If we move on to the next slide, this is where we get into the types of data that are permitted for your bias audit, but it is very situational. So the default here is that historical data must be used when conducting a bias audit for an AEDT. These historical data, in fact, they don't just have to be your data. They can be from one or more employees or employment agencies using that same tool, but the individual employer or agency may rely on the bias audit using historical data of other employers in very limited circumstances that you have to follow. So the first provision is that if you use historical data for that AEDT, you have to have also provided that data down the road. The other is you could use historical data if such employer or employer agency has never used the AEDT prior. Additionally, we have situations where testing data can be used. An employer or employment agency may rely on the bias audit that uses test data if the historical data that they are capturing is insufficient and is not able to conduct a statistically significant bias audit. What DCWP has not done, though, is define what that statistically significant threshold is. And so whether or not they capture that in the FAQ remains to be seen. But there are some gaps in the terminology that are being utilized in the final regs. You could also use the testing data if the summary results of the bias audit. You could use it, but you have to explain why you're using testing data and why the historical data that you might be capturing is insufficient for these bias purposes. To kind of box this all up and provide further clarification, they provide 3 illustrations in the final regs. So on the next slide, that's what we will go through. So the first bucket is that first-time user of an AEDT. What may you rely on in the bias audit is historical data of other employers or the testing data that the vendor collected when developing the AEDT. The next is a situation where an employer is using an AEDT for 6 months. They conducted their bias audit 10 months ago. What happens when you approach that year period? So in that case, the employer will need to update the audit, of course, once every 12 months, but the data that was collected for the 6 months of use of that AEDT won't itself be statistically significant to use in your bias audit. In that situation, what you get to rely on is the historical data of other employers, and as long as you provide that 6 months of data that you captured to the vendor that developed the AEDT. The employer may rely on a bias audit of testing data as well. For 3 years, for the situation where an employer has used the AEDT for a significant period of time, over a year, so here they say 3 years, and you have that statistically significant set of data, you may rely on the historical data for your bias audit or the historical data from multiple employers if you provided that 3 years of historical data to the independent auditor for consideration. But in this case, you cannot use the testing data. You're now outside of that scope. So I know that we've covered a lot. I'm not sure if we want to cover any questions that might have come in, Annette, or move on to.
No, yeah, we should move on. I've been answering
Okay.
questions as they come in.
Perfect.
Thanks.
All right. So with that, I am going to kick it back over to Rob to discuss the notice requirements of the law.
Terrific. Thanks so much, Joe. So we're going to talk about notice and disclosure requirements. And although there's seemingly only a couple of words on this slide, as we're going to start seeing on the next slide, we're talking about a variety of different obligations, and we'll drill down on each of them respectively. So first and foremost, we're talking about bias audits and conducting bias audits. One of the key requirements of this law is that the results of that bias audit has to be posted publicly. That is an annual requirement effectively because those bias audit results are only good for about a year. In other words, the law says you cannot use an AEDT unless it's been bias audited within a past year. So let's dive into this requirement a little bit. An employer is required to make publicly available the results of a bias audit on its website in a clear and conspicuous manner. The results or the summary of the bias audit has to include key data such as the date of the bias audit and a summary of the results, such as the source and explanation of the data that was used to conduct the bias audit. Exactly what Joe was talking about. Is this historical data? Is this a compilation of data? Is this test data? The key thing about using test data and sort of compilations of data, the default setting is going to be that an employer use historical data. That's what the Department of Consumer Affairs expects. Everyone will eventually get to the point where they'll be using historical data. If there is some reason that historical data is not used, for example, test data or a compilation of data is used, the bias audit results are supposed to be explaining as to what the problem was. What was there no data available? Was there some other reason? Was there an insufficient sample size that was being that the employer had and had to be compiled with other employers? That explanation will have to be given. Next, the number of individuals that the AEDT assessed that fall within an unknown category. So, for example, if there is a data pool of X amount of individuals, there may be, especially in historical data, a certain amount of individuals who decided not to disclose certain information or didn't provide certain information. If they're included in that data set, the number of those individuals will need to be disclosed. So, for example, out of 1,000 individuals, if 5 of them didn't disclose information, that number of 5 would need to be summarized. Next, the number of candidates or applicants, the selection or scoring rates, and the impact ratios for all categories. So effectively a summary of how many individuals were part of the bias audit and what were the effective results of that bias audit. And Joe went into the details as to what some of the bias audit requirements are. I don't have to duplicate that, but effectively, what were the numbers that the bias audit came out with? And the distribution date of the AEDT. When did we start using it? How long has been in effect? If it's been intermittent use, for example, that information. To explain a little bit as to how that is disclosed, the Department of Consumer Affairs explains that an active hyperlink can be used on a website to bring someone to that information. So if it's a link on the jobs or employment website of an employer, that would be okay for compliance. Also, those bias audit results, that summary, has to be posted for at least 6 months after the latest use of the AEDT. Now, again, this is a effectively annual requirement, so the prior bias audit result, as well as the current one for some time, may have to be up on the website for 6 months after the prior bias audit expired. As we see on the next slide, the additional notice, there's an additional notice component to candidates specifically. So not just the bias audit results, but also a specific notice to candidates that talks about, first and foremost, discloses that an AEDT will be used and advises that there may be an alternate selection process or reasonable accommodation. That really touches upon disability accommodations or accommodation requirements. There is no requirement under Local Law 144 that an alternate process has to be created or given. It simply is a requirement that if there is a reasonable accommodation, how it can be requested. Now, the employer has to provide this notice to candidates in the city. Again, we talked about that jurisdictional component, and there are a variety of options. The posting in the job posting itself, the notice could be distributed by U.S. mail or email. And for job applicants and candidates for promotion, there's two distinctions because ones are internal employees, the other ones are external. For job applicants, on the employment section of the website, for candidates for promotion, the notice can be given in an internal policy or procedure. Now, for different employers, those notice options may make sense in some instances and not others. Very fact specific. For some employers, the optimal way may be a job posting itself. For others, email. For others, yet on the website itself. The key thing to remember is that the notice is not job specific. It's not AEDT. It's specific to an AEDT, but it's not job specific. So it doesn't have to be for each posting that's posted, just that the AEDT is being used for selection for positions. That notice has to be given 10 business days before the first use of an AEDT. So once that disclosure is made, the AEDT could be used 10 business days after and going forward. So that is an important distinction to keep in mind, that it's not job specific and 10 business days before the first use of the AEDT, even if it's used for multiple jobs and multiple postings come up after the fact. Now, moving on to the next slide, we can talk a little bit more about yet another notice that has to be given to candidates. So there must be a notice that informs employees and candidates of the fact that there's an AEDT that's being used and the job qualifications and characteristics that the AEDT assesses. So independent of the bias audit, independent of the notice that we just talked about to candidates, this obligation really talks about what the substance of that notice has to contain, what the AEDT is, what it assesses. Additionally, there has to be a notice that includes information about data collection. For example, what data is being collected, what the retention policy is, where that data came from, and instructions on how an employee can request more information about that data. Once that request comes in, an employer would have 30 days to comply with that obligation. Next slide, please. So as we're talking about these different notice provisions, the Department of Consumer and Worker Protection has come out with some suggested best practices for employers to consider. For example, being records of all electronic tools that are used to assist in hiring and promotion. That may be broader than just the AEDTs that are being bias audited. That may include other tools as well to keep a record of, and perhaps to identify which tools do constitute AEDTs, which do not. Another piece is how electronic tools are used and what methods are used to evaluate candidates. Very important in determining whether something is an AEDT, as Annette explained, as well as copies of notices and methods of notice being provided to the candidates. At the end of the day, employers will may need to provide information as to how that notice went out. Last, for an AEDT that assesses employee performance, informing all staff of the use of that AEDT at least 10 business days prior. In other words, likely creating an internal policy that apprises everybody of what the AEDT is and how it works. So these are, in a nutshell, the various types of notice. When we say notice and disclosure obligations, it actually is a multiple moving parts, multiple disclosures and multiple notices that employers have to consider when using AEDTs and disclosing the bias audit results. With that, I'll turn this back to Rachel to tell us a little bit more about EEOC requirements.
Thanks, Bob. Besides the EEOC, though, I want to talk about some of the really big picture regulatory environment, the very complicated regulatory environment that the New York City Local Law 144 is operating in. So on the next slide, you'll see some attempt to visually depict all of these overlapping regulations, and this is by no means comprehensive. We have some very specific federal regulations, an executive order borders on some very narrow categories. In the middle part of the slide, we have big picture federal civil rights laws, Title VII, the ADEA, the Age Discrimination Act, the Americans with Disability Act, and the Genetic Information Non-Discrimination Act. Those are federal civil rights laws that apply to the use of AI. We have state and local laws, not just New York City Local Law 144, but other states, Illinois, California, Connecticut, has passed something that all of these state legislators are reacting to what I'm sure you all are hearing in the news, and fear and concern from people, and feeling the need to do something, to say something, and to throw their hat in the ring on regulation. We have, in addition to the US, we have a complicated international regulatory environment. So yesterday, the EU Parliament passed the EU AI Act, which does categorize employment applications as high risk. There are other countries that are in various stages of AI specific regulation, as well as a similar framework to what we have here in the US. So on the next slide, just to give you a taste, the New York City and New York State laws alone that can intersect with an employer's use of an AEDT are on that slide. But let's really talk about the federal efforts, the US federal efforts. So on the next slide, we have President Biden saying things very recently, some very intense scrutiny and activity from the White House and White House organizations such as the Office of Science and Technology Policy, OSTP, issuing some really big picture statements about AI and AI risk. And the context that the government is talking about AI, that leaders are talking about AI, is both the opportunity and the civil rights threat. And so President Biden's statements go to both the benefit and the risk. And you have some very robust activities from some agencies, and in particular, I would commend you to the AI risk management framework that NIST put out in January of 2023. Don't just read the AI risk management framework, also read the playbook, which has a lot more detail, including some technical detail, but it's quite accessible to non-techies. But bringing it down a level from government-wide activities to employment, on the next slide, we have some discussion about what the EEOC, where I was for 5-6 years, is doing on AI. So the starting point when talking about federal law and AI is that our existing federal civil rights laws apply to the use of AI. When I first started doing this work, it's like, well, is that really that surprising a concept for people to hear? But when a bipartisan message went out that, hey, our existing civil rights laws apply to the use of these AEDTs, to the use of AI, algorithms, technology, and hiring, and if you have a result from the use of technology that violates existing civil rights laws, that gets you to disparate impact against a protected category of employees, then you have a violation of the law with all of the remedies that claimants, plaintiffs have, and the government on enforcement have available to them. So what the EEOC has put out, in addition to conducting its public listening hearing sessions and a commission meeting on the use of AI, what the EEOC has put out are 2 technical assistance documents, one in May of 2022 and one this year in May of 2023, applying principles under our existing laws to the use of AI. So the first piece of technical assistance was in 2022, which said, perhaps uncontroversially, that the Americans with Disabilities Act applies to the use of algorithms, including artificial intelligence. And in May of 2023, a couple months ago, last month, the EEOC put out TA, that's 2 slides forward, that talks about how Next slide, please. That talks about how Title VII and the principles in Title VII, prohibitions against disparate treatment and disparate impact, these concepts apply to the use of AI. The May 2023 TA also talks about guidance from 1978, the Uniform Guidance on Employee Selection Procedures, UGASP, which talks about selection procedures. So these are the 1978 guidance. This is the 1978 guidance that the EEOC and other agencies put out, setting forth the test that you heard Joe talk about, some of the tests that you heard Joe talk about earlier, that the New York City DCWP has said is part of the minimum standards for a bias audit. So they're applying that test, those calculations from UGASP. Next slide, please. So what these existing EEOC technical assistance documents do is they're emphasizing that our long-standing principles against discrimination apply to new technology. And if you read these documents closely, you'll see that the EEOC takes an extremely broad view of the types of technology in the employment process, in HR process, that it has authority to inquire about and go to enforcement if it finds a violation. So yes, they call out specifically resume screening software. They call out very specifically interview software or chatbots, and assessments, computerized tests, and video interview processes. So the technical assistance documents name specific types of technology. The other perhaps scary thing that we've seen in the past few months, next slide please, is leadership from the EEOC talking about enforcement. So in January 2023, as part of its strategic enforcement plan, the draft strategic enforcement plan, the EEOC is talking about how the use of AI is going to be one of their new strategic enforcement priorities. And in May of 2023, the Daily Labor Report did publish an email from EEOC Chair Burrows announcing all hands training about AI in the employment context and how their enforcement staff can identify AI-related issues in enforcement work. Okay, so where does this leave us? We do have some takeaways from you for all of this. On the next slide, we have our first takeaway, which is that if you're an employer and you're using a tool that a software vendor provides you, you can be liable for the results that you get out of the tool if you act on them. And so whatever the New York City DCWP says, whatever local law 144 says about minimum requirements on bias audits, there is liability under federal law, under Title VII and the other statutes that the EEOC enforces, that employers should be mindful of. And so asking vendors what steps they've taken to ensure that their tools don't have, as we say, a substantially lower selection rate for those in protected groups, that can be part of your due diligence. The other thing on the next slide, our next takeaway, is somewhat technical. So the EEOC's technical assistance talks about the 4/5 rule. Now, we won't get into the 4/5 rule too much here. There are some vendors who cited compliance with the 4/5 rule as, quote unquote, compliance with EEOC requirements. And what the May 2023 TA really emphasizes is that the 4/5 rule, according to the EEOC, is a rule of thumb. And so it's not a strict mathematical test where if you're over this selection rate, if you're over this ratio, you're fine. And if you're under it, you're not fine. That is not what the EEOC has said. And that was a wake-up call, I think, to some folks in this space. And the TA document cites very old cases talking about how the 4/5 rule is not always appropriate. So this is a reminder to folks that this test was a rule of thumb. And our next takeaway is encouraging folks to be very proactive in looking at algorithmic decision-making tools and disparate impact. Okay, so my prediction, my first prediction, biggest prediction on the next slide here, is that you're here learning about local law 144. And my prediction is that published bias audit results will be used to identify targets for both private litigants and government enforcement. We've seen in the news, not related to a bias audit for local law 144, but a plaintiff's firm has already filed a class action suit against a major vendor alleging unlawful discrimination based on the use of algorithms. We have civil rights groups from both the right and the left giving increased scrutiny to the use of these tools. So from an advocacy perspective, there are folks who are saying, well, wait a second, we have concerns with the way you're emphasizing diversity, equity, and inclusion, and that falls into some political agenda there. And on the civil rights side, there are many concerns about unlawful bias and the ways that algorithmic decision making can entrench and amplify existing biases. And so there's scrutiny on these tools from both sides. And on just a nuts and bolts enforcement perspective, on the next slide, we do have an RFI, request for information, from the EEOC, very specifically asking about the use of algorithms and AI that's been issued. Okay, running out of time here. So on my last slide here, I have, which is next, I have some very big picture questions. Oh, we should give the CLE code. The CLE code is SS9474. That's SS9474. Okay, so on my next slide now, we have our very big picture questions to keep in mind as you're looking at AI risk, as you're looking at implementing AI. Number one, very threshold question: does it work? And how do you know it works? And if you have to prove to someone else that it works, how are you going to prove that? If someone's selling you this tool, if they're saying implement this tool, how are they showing to you how they've analyzed you, the buyer, you, the implementer, you, the executive, who's saying, how have they analyzed potential bias against protected categories? And oh, by the way, how does this tool work when presented with people with disabilities and requests for reasonable accommodations? So, the scope of all of that analysis, that can be complicated. And so if you're an HR person or a business professional, do you have, or someone on your team, do you have the technical expertise to assess these representations? And even bigger picture question, which I'll leave you with as you think about these very big picture questions within your organization, what structures does your organization have in place to evaluate both the benefit of these processes, of this technology, and the risks? And so how are you identifying risks? How are you managing risks? And what structures, what governance and risk management structures do you have in place? Bob, I think you have a few minutes for the recap here on the next slide.
Terrific, Rachel. Thanks so much. One of the important things that needs to kind of be gleaned from this entire discussion is that, as Annette pointed out, some of the key definitions of what an AEDT is, and we walked through the analysis. Among the different jurisdictions, New York City has its own definition, but among the different jurisdictions, there really is no uniform definition of quote, unquote, artificial intelligence at this time. Different jurisdictions have different versions of that test. That is for sure an analysis that needs to be performed on a case-by-case basis. The definitions and the concepts generally are very broadly defined in order to be inclusive of the type of technologies that they capture. and many jurisdictions across the United States, different countries, municipalities, counties abroad in China and in Europe are looking at artificial intelligence regulation and looking to pass various forms of obligations and restrictions and regulations as to various aspects of AI. What we have also seen is that the EEOC and other federal agencies have released various guidance, guideposts, recommendations, and shared their views as to what existing law really requires of employers and various stakeholders in this area. So with that, ultimately what we're seeing in the AI space is that this is a very much budding industry. To Rachel's point earlier, AI is here. I disagree with Rachel on the fact that we haven't seen any robots, as I was at a restaurant this weekend where I had a robot instead of a waiter. So the future is here indeed. With that, we thank everybody very much for your participation and for your attendance today. We greatly appreciate it. We saw a lot of comments come in and questions come in. If we didn't get to your comments or questions, we're more than happy to connect offline. Thank you so much, and we hope you enjoy the rest of your day. Thanks.